Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut. And today, what I'm going to talk about is hearsay in the context of a family law or divorce case. So, hearsay is defined by Connecticut Code of Evidence, Section 8.1. And it says that hearsay is a statement other than one made by the declarant while testifying at the proceeding offered into evidence to establish the truth of the matter asserted. So that's a little bit complicated. So I'm going to I think a better way to put it is that hearsay is an out of court statement. So that could be an oral statement or a written statement. So an out of court statement offered into evidence to establish the truth of the matter asserted. So it's offered into evidence to establish the truth of whatever that statement was. And again, it can be a little confusing, so I'm going to use a few examples to try to help you understand it. So the first example I'm going to use is a child custody proceeding where the mother is claiming that the father is hitting her child, their child. So in that scenario, if the mother's testifying and she says that she knows the father is hitting their child because the child's uncle told her that he saw the father hitting their child. Now, that is inadmissible hearsay. It's clearly an out of court statement that the mother is trying to introduce. She's trying to introduce the statement of the uncle, which is him telling her that he saw the father hitting the child. So it's an out of court statement, and the mom is using that to establish the truth of the matter, to establish the truth of what was asserted by the uncle. She is saying, the father is hitting our child because of this statement, because my uncle, the child's uncle told me that he saw the father hitting the child. So that is inadmissible hearsay. It's clearly an out of court statement offered to establish the truth of what was stated. The more appropriate way to introduce that evidence would be to have the uncle actually testify in court as to what he saw. If he testified to that, there would not be any hearsay issues. I'm going to give you another example, which is which is not hearsay, but it seems like it might be hearsay. So let's, in that example, use a child custody proceeding where the father is claiming that the mother violated a joint legal custody provision by taking their child to the doctor without consulting her. So in that scenario, mother could testify to the same thing, that she says she took the child to the doctor because the child's uncle told her that he saw the father hit the child. Now, in the context of the child custody proceeding where the father is claiming that the mom violated the joint legal custody provision by taking the child to the doctor without his consent. In that context, that statement is not necessarily hearsay. The mother's defense might be that she took the child to the doctor because she learned this information from the uncle. So again, the statement of the uncle that he saw the father hit the child, yes, it is an out of court statement, but it is not being used to establish the truth of what the uncle said. The father hitting the child is not at issue here. So the mother is not using it to establish the truth of the fact that the father hit the child. She is using that statement to show the impact that that statement had on her. Because she heard that statement from the uncle, she felt that she needed to take their child to the doctor. So she's not using it to establish that the father hit the child. She's establishing it to show the impact it had on her, that is the reason why she took the child to the doctor and didn't necessarily tell the father about it. Now, that doesn't make it okay. That doesn't, just because it's admissible doesn't mean that she's justified in not telling the father about it, but it wouldn't be hearsay if she's using it to establish the impact that the out of court statement had on her. So that's an example of kind of a scenario where something could be considered, something is hearsay and is not necessarily hearsay. Now, there are exceptions to the hearsay rule where hearsay is admissible, even if it is clearly hearsay. And I will go over those sections in another video. So as usual, if you have any questions about hearsay in the context of divorce or family law cases, you can feel free to contact our office at any time.